Welcome to the DWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the DWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 90 of the DWI Guy podcast. On today's episode, we begin our DWI Masters Series. We're going to have a series of episodes where we get to listen and hear from some of the best DWI lawyers in the state of North Carolina. And we're starting the series off with none other than James Davis. Very excited, very honored to have James Davis on the podcast. He's going to be on today to talk with us a little bit about his approach to DWI cases, why he got interested in defending people charged with DWI and other crimes. And then on the next episode, 91, James will be back on to kind of walk through his approach to jury cases. I think you're going to find that to be an incredible episode. If you handle any amount of DWI jury trials, you need to listen to that episode. If you don't handle DWI jury trials, you need to take DWI cases to trial in district court and then appeal it and win in superior court. So listen to James talk about how he approaches cases, DWI cases in superior court. But it is an absolute blessing to have James on the podcast. In episode number 53, I talked about James's 10 incredible resources for North Carolina practitioners. I talked about James's DWI trial notebook. It is one of the most powerful resources that exists on the web. Easy access. Go to davislawfirmnc.com. davislawfirmnc.com. If you click on the attorney's page and go to James Davis's page, you'll see it in the list of resources at the bottom of his attorney profile page. James is a board-certified expert in state criminal law, in federal criminal law. He has tried hundreds of cases, and even though he is an incredible trial lawyer, and I mean an incredible trial lawyer, he has always been, to me, a first and foremost educator. And that's probably because that's been my main interactions with James. James taught at pretty much every DWI CLE that I went to for the first 5 years of practice. I felt like every time I went to a DWI specific CLE, James was there to teach about how to best represent clients charged with DWI, to teach how to cross-examine an expert, to teach how to challenge a checkpoint. He was always approaching the law with a teacher's mindset, with a mindset towards how can I learn this better, understand this better, and then communicate it to others. James has done an incredible job sharing his knowledge with the defense bar. It has been a passion project for him to share his knowledge. Please go to his website, and at the bottom of his attorney profile page, just see the amount of resources that are on there if you practice DWI cases. It is an incredible amount of free information that he has put out there for us. So excited to talk to James Davis, and hope you enjoy listening to today's conversation. Maybe just start by telling us a little bit about kind of why you became a lawyer and what about criminal law specifically interested you, or at what point did you kind of start going down that path, after law school?
Well, Jake, I would say just for me, I was probably born into it. My family was deeply rooted in politics. My dad ran for U.S. Congress when I was 8. He was a state senator. It's all throughout my family. We used to have debates probably nightly in our home. I learned a lot about public policy and how to support your position or to be quiet. My dad was a lawyer for 54 years. My uncle was a lawyer and a retired Superior Court judge. It was kind of just in my family. So I would say that I'm really born out of it.
Yeah, and when your son was on the podcast, we were laughing a little bit about that because of just how that academic background, plays into both the work environment and the home environment as well. And I said, it's probably more like being in a law school faculty lounge in the office than it is like being in a law firm.
It's the truth. And my son, I'm naturally very proud of him. I think he's an excellent lawyer, but he's a heck of a good guy too. Yeah.
Yeah, no, he definitely is. Well, in terms of that kind of passion project, or being born into it, kind of going down the criminal path, was that something that also was kind of in your family, or what point was it that specific area of law kind of caught your interest?
Well, I think I did look at a variety of different possibilities. Law school sort of makes us all think through the options. But I would say that because my dad was primarily a criminal defense lawyer, and that he helped shape my views and deepen my perspectives over the years, I literally got out of law school and started, within 1 year, I was trying murder trials.
Wow.
Now, I often laugh about that because I'm not sure that's not malpractice. But the truth of the matter is, it was I did learn by fire, and I learned how to value freedom and how all about the presumption of innocence and all the sort of fundamental features of our society, and the power, whether the power is in the legislature or what, and it's a government of the people, by the people, for the people. So I would say that I became a criminal defense lawyer because I first started practicing with my dad.
Yeah, I guess, we're going to talk about this maybe a little bit more in depth later when we kind of get into the, jury specific considerations in terms of jury trials. But, coming out and so quickly being involved in a murder case, and a case that then goes to trial, I don't think that there's too many people currently that come out of law school into that environment, right? Like if you're in the public defender's office, you're not going to be able to do that for probably a significant period of time. DA's office, same thing. What do you think that did for you in terms of your perspective of handling a pretty serious case or taking it to trial at such a young age?
Well, I think it made me courageous. I would say that, law school's daunting, the practice of law is daunting, but I think that just being thrust into it, where Dad would just about say every other witness, it's your witness, with little to no prep. And back then, we didn't receive the discovery, like witness statements, until people were called to the stand. And then, believe it or not, the prosecutor would hand you their statement.
Wow.
So you had to listen to them testify and try to read the witness statements and prepare your cross simultaneously. So I think it made me courageous. You're either going to sink or swim. Although I think they do a much better job today in making sure that people have years of practice, they get the right kind of training. I remember, I was in law school in the late 80s, and, they were having real estate lawyers take murders as assigned counsel. And as opposed to today, people are well groomed and well trained. So
yeah, it definitely has become a lot more specialized, in terms of practice area. But I do think that there is such a value of being thrust into it, because you just get used to saying yes to trial. If the offer isn't great, okay, well then let's just try it. Instead of it becoming like this pressure point mentally of, well, man, I don't know if I'm ready to take this case to trial, or I don't know if this is a good issue. It's kind of like the default position is it's for trial, unless there's a real reason to either enter a plea, or we've got the right offer on the table that my client wants to accept. I feel like eliminating that barrier, where just kind of the thought of taking it to trial is something that as a younger defense bar, we've got to figure out how to get over, because there's less and less cases that are just kind of, set for trial from the get-go. It's always like, this is a plea until kind of the facts are too bad on the state's end that I've got to force their hand into a trial. What is your thought on that end of things?
Jake, I think you're just bringing out a fabulous point. And this is a practice pointer that I try to tell people and teach. I am fairly quick to go to trial, but I'm going to be cautious. I'm going to look at everything carefully, but I give you this paradigm, this model. I'm all in everything that I do. What I try to do is analyze it in a trial posture. That is, look at all the witnesses, look at the legal theories, look at the instructions, look at all the salient facts, do all the motions practice, make sure there's nothing out there that we don't know about, that we haven't, had a judge review in camera or give us Brady evidence or whatever it is. So we're really prepared, and I use a trial lens. If I think there is a good possibility or probability that we get a better result at trial, then I'm going to tell the client that. And I think I'll advise them to go to trial. It's all about them. They make their decision. But if I lay out the good and the bad, I do believe a lot of times prosecutors don't give it quite as good a look. They give it more of a cursory look. And just sort of depend on their experience. So I think there are a lot more triable cases out there. And I would say that to any young lawyer, do all your homework first and use your good judgment, because your judgment's worthy. You have a fresh perspective, see things like the jury of your peers would. They're just normal people. And I think you'll surprise yourself. Use a trial lens as your barometer.
Yeah, kind of to piggyback off of that, in terms of this increased specialization and needing to, there's such a wealth of information out there about, specific types of practice areas, but also even within criminal law, so much information out there about specific crimes. And, DWI in particular is a charge where there's just so much information out there, and there's so many technical points, so much to know. And I think that again is a good thing, that there's all that knowledge and information out there, but it also can be debilitating in terms of feeling like you're adequate, in terms of your preparation to take a case to trial. So for a new lawyer, that kind of recognizes there's quite a bit out there that exists to be known on a DWI case. And there's a lot of issues, a lot of procedural problems that can come up. I think that there is a real debilitating feature to that, in terms of, well, I'm just not going to be ready to take this case to trial, or, the state must almost like know something that I don't know about this. And so I just don't want to look silly in front of the judge because I don't have all of this fully within my grasp. And I think that's where, like you had said, in terms of, learning to be courageous, that I think is where you get that opportunity.
One other thing, Jake, have a mentor. I would just tell anybody, I'm always
totally
glad
agree
to
with
answer
that.
questions. And so, people will come and say, hey, I'm not sure about this issue, or is there a notice problem, or how do I get to this piece of evidence? If you have someone that you can run things by, and I tell people I'll answer any question anytime, because I think we're adding to the quality of life and the quality of service that we give other people. And one of the things that's so good that I try to remember, we strive for perfection, but look, it's the practice of law. It's not the perfection of law.
I like that.
I've never tried a perfect trial. I always look back and see what could I have done better. It's the practice, and we're genuinely good people giving our best, and that's how we ought to see it.
I love that. In terms of specifically preparing for a DWI case and how you use the consultation as the first means of that preparation, what are some tips or methods that you use during the consultation to give yourself the best chance of taking a case successfully to trial or getting the best outcome for the client in the courtroom?
Well, I've got a few thoughts about that. One of the things that I do is I'm very thorough in my intake. So anybody's welcome to have a copy of my intake sheet. I have a criminal intake and a civil intake, and they're designed for what's relevant for those kinds of areas. What I would say to you is spend the time getting the background of the individual, truly teaching them the legal procedure and process, make sure they understand the elements. Spend the time with them to really give them a fundamental understanding, and then do a deep dive into the facts. So on the intake, take a lot of time to make sure I ask a lot of questions, because some people have a good memory, some have very little memory. And of course, you'll augment that later by getting the officer's notes and petitioning the Superior Court for the videos and getting body worn cameras and all the other things. But make sure that you spend a lot of time teaching and listening in the initial intake, particularly about the facts, particularly identifying the legal issues, whether it's a stop issue, whether it's a probable cause to arrest, whether or not there's some issues with testing results. But then I would make sure that I spent time about possible outcomes. We have a sheet that we give people for what can happen with suspensions and ignition interlocks. I think it's real helpful to take the time to give them a panoply, sort of a full understanding on the beginning intake. That will help you sort of give you a starting point as you continue to develop the facts and look at the evidence of the matter.
Yeah, I think particularly asking a lot of questions is so helpful, in terms of getting, trying to draw that information out from the client, with regard to what the issues are, which, field sobriety tests were performed, where were they performed, what instructions do you remember being given about these things? And again, it's not going to be 100% accurate in terms of the information that you're getting, but I do think that you can start to spot holes in the state's case from your client's perspective. I think it's not helpful really to just wait until the officer's report comes back before you start that investigation, because then you kind of already put your mind into the state's positioning, right? If you've got your client that you're representing and you're on the other side of the V, you've got to get your client's story first. And again, there may be inaccuracies, there may be memory holes in terms of certain things, but at the same time, that's the only real way to kind of get the both sides of the story, so to speak.
Yeah, Jake, I think you make an excellent point. I use the defense lawyer's lens. I start everything with the defense lawyer's lens, identifying potential legal issues that I want to be sure about. Because if you come at it from the officer's vantage point or the prosecutor's, you're never going to see the issues. They'll gloss over them.
Well, in terms of, district court preparation and trial, what does that look like on your end in terms of how you begin to prepare for a district court trial? At what points do you kind of refresh your the issue with the district court trial, unlike a superior court trial that we'll talk about a little bit later, is that you may get all prepped for trial and then it gets continued, and then you get prepped for trial again, it gets continued the next time. So there's definitely a lot of refreshing that goes on sometimes, depending on the specific case. What are some of your preparation strategies as you're looking at a district court case?
Well, really, I just give a few principles for advice. The first thing you need to do is you need to have a command of the facts as good as the officers, maybe better,
Yes.
but you have the defendants.
Totally agree with that.
The second thing that you need to do, you need to have identified the issues that you believe that you may win, that you are, and you've done the legal analysis, so you have the cases, and you can teach the judge in a matter of 20 seconds. You make your point, you show the case, and you move forward. So I think you have to have identified the issues and know generally where you think you want to go. The third point that I would make is that trials never go as they're planned. So I would always say, listen and be fluid in your response to it, because a lot of times they'll say one thing and they'll add to their report or do other things. So be fluid and listen to what they say. And then I think finally, the fourth thing I would say in district court, probably the most important thing to do is know your judge. Some judges will not. I had two trials the other day, and I took a chance on a judge, and I did a suppression hearing on one case and a trial on another case. And the judge had told me previously, James, don't ever do a suppression case in front of me. I don't want to hear that. And so the officer literally didn't remember anything. It said, I don't know. So I testified it's their burden. I said and argued it's their burden of proof. Here's what the officer said. Still, granted, did not suppress the evidence. And so what I would say to you is know your judge, know what issues they're willing to hear, and then get right to the point. When you're going to do a district court trial, most of those judges, if they're older judges, they want to crystallize the issue and tell them why you win quickly. That's what I'd say.
Yeah, I think those are four really powerful points. The first one, for whatever reason, just kind of stuck out at me in terms of having the command of the facts stronger than the officers. If you want to turn an officer into a yes man, if you want to turn them into somebody that is going to give you the answer that you're looking for, the best way to do that is to show from the get-go your level of preparation. And a really easy way that I have found to do this is by asking questions that seem like you've kind of done a lot of research, but really just require a map quest. So if you got an officer that is going along some city street, make several turns, see your officer. If you say, and this, where you first saw my client was near the Rockies Chicken Shack, is that right? And from that location, it's about 0.2 miles until you get up to the next light that you saw him. And then he took a right onto Choctaw, and that's where the Walmart is that right? And then he was driving down 0.5 miles. Again, all of this is easy information to find, but from the officer's perspective, it's like this guy came in really prepared. And now I don't want to make a mistake about anything that I say. I don't want to go outside of the report. So you just start to kind of build in that idea that this person really has a command of the facts. If I don't know something, I better say I don't know. If he's asking me yes or no, and it sounds like the answer should be yes, I'm going to say yes. I mean, that to me is one of the most powerful advantages that you have, is that better command of the facts. And it's not hard to do, because the officers have so many cases that they're trying to remember. So their memory is tied up into whatever, 3 or 4 paragraphs that they've put into that report. There's no external memory. Most of the officers don't watch the video before they come in and testify, at least not in the counties I practice in. So you just don't see, anything outside of that report is just kind of, it's like it didn't happen, whether that's good or bad. But I think that that's a really powerful place in district court.
I agree.
In terms of anything that you do specifically at a trial in terms of getting your client prepared, what does that look like in terms of communicating to your client the trial process? Does that happen, the day of court before? What is communicated to the client? I guess just trying to get your client ready for trial. What does that process look like for you, or what tips do you have for attorneys in terms of getting their client ready for a district court trial?
Well, it's pretty much the same format, whether it's assault inflicting serious injury or DWI or whatever. I think that I should be able to say succinctly and to the point what the key issues are. And what I do is tell the client, when I hear their responses, either on the initial interview or when I hear them at a later time, and if they give dubious language, well, as best I recall, or I don't remember that very well. Whatever their language might be, I am quick to tell people, if you don't remember, the officer does. If you're doubtful about your position, then they accept the position of the one who says, I remember.
Right.
So, and if you're ambiguous, don't get caught up in being wrong. If it's a time or a distance, use approximations. And I tell people all the time, we walk through the key parts of the testimony before the trial. And I like to do it in a conference room, because usually the trials are last in district court. So I'll do it in a conference room before we start the trial, so it's fresh in their mind. What are the key points? The rest of it, I'll let them go ahead and just testify. So it's fluid, it's them, it's the way they speak, their manner of speaking, their recollection. But as it relates to the central issues, I make sure I cover that pretty much immediately before trial, when it's freshest, and to keep it fresh on their mind.
And then I guess in terms of the last preparation point for district court, as you're actually preparing for a district court trial, so you've identified the issues that are likely going to be brought up on your end in court. What does the preparation look like? Do you write out cross-examination questions? Do you have a prepared argument? In early practice, I did that a lot. I would write out all of the questions and write out kind of what my argument was going to look like on a specific legal issue. I really don't do that anymore. I kind of approach it with more of a fluid way of dealing with the case. But we've got a couple of attorneys at the office that have been doing it for many years, and they still write out all the questions. And I think that there is some benefit to making sure that you don't miss a specific point that you wanted to concentrate on. So in terms of, whether it's, watching the video and taking notes, or the way that you write down questions or argument, what does that part of the trial preparation look like on your end?
I appreciate you asking that question. I've actually taught this point many times to lawyers. I don't think it's effective to write out questions. I think judges know when you're reading from questions. I think that it doesn't allow for when somebody gives you that nugget and you need to follow that trail. I think it's repetition and rote, and it militates against the vibrancy and impact of your examination. So here's how I do it, and I do it this way in Superior Court and everywhere. If I have a piece of paper sitting in front of me, I just draw a line to the right of the paper, like 3 inches off the margin. And then what I do is put their name up, and I'm recording the material comments that they make as I go down. But in advance of the trial, or as I hear something that's important, in that right-hand margin, I do an asterisk, and I make a note a phrase. or I note a subject that I want, or I put in quotation marks 3 words that are the pearl that I was hoping to hear.
Yeah,
So
I love that.
I have in that right-hand margin what is a reminder checklist. Like if there are 6 different things that are important, I know that that witness has got a bad criminal record. I know that that witness consumed alcohol, or I know that previously they had given an inconsistent statement, or whatever it might be. So I have a little checklist. That way I can follow their testimony, object when I need to object, and I can just stay right with them. But when I'm at the end of my examination, I have this quick checklist that I can go back to and say, let me address this point with you. So that's how I do it.
Yeah, I love that. I think that that is a really powerful way. Was that something that you developed, or was that taught? Where did you come up with that way of doing cross-examination?
I developed it over time.
Yeah, I think that that is a really powerful way. I think, you know, if you if it comes across too scripted, it really does start to break down the conversation. And I also think it can sometimes give the officer a little too much time to kind of recalibrate. You know, if you're so committed to the script that you can't really break away from it to follow up, like you said, in this specific place where there was a hole that was left, and you know, now it's just not identified because I feel like I've kind of adequately done everything before. You know, it really can just make it feel forced in terms of how that conversation then comes out from the stand. And I would assume that a lot of your jury experiences probably also played into that, because it's even more painful in front of a jury than it is in front of a district court setting to have that very kind of scripted feel to things.
Yeah, that's 100% true. You just got to remember that juries, they're people like you and me. They're like our parents. They're like our friends. They're like businessmen and women. And you just have to think, look, they're going to use their common sense, their life experience. They know when something sounds funny. If it sounds funny, dive on it. They already think it sounds funny.
Yeah.
So I look at jury trials through the lens of an ordinary human being. And I just spend all my time relating as an ordinary human being. I've got a lot to say about that whenever.
Well, yeah, maybe that's a good place for us to kind of segue into that direction. You know, the jury setup, this kind of, again, daunting feel of taking a case to a jury trial. If you've never done a jury trial, you'll definitely feel a lot of anxiety before that first case is called, before the jury enters the courtroom, and you'll probably feel that for the next 100+ trials. There's some aspect to where there's no way to eliminate that anxiety, as long as it's a healthy anxiety. That's at some point it gets a little bit more livable. But yeah, just in terms of your experience trying cases, maybe just talk a little bit about the different types of jury trials that you've had, the number, because I think it's helpful for people to have a little bit of perspective about your experience level on that front, James.
Sure. I'm not sure how many jury trials I've done, 100 to 150. A lot of them have been very serious trials. I've done 8 murders to verdict. I've done lots of rapes and robberies and traffickings, but I've also done lots of civil trials. I've done lots of personal injury, alienation of affection, criminal conversation, malicious prosecutions. I've brought a lot of different kinds of jury trials, and we've won very substantial verdicts. Not guilties in capital murder, not guilties in non-capital murder, not guilties in lots and lots of others, but also multi-million-dollar verdicts on some other cases. So
let me actually just dive in there for one quick second, because I think that's a pretty unique position that you come from, in terms of having such a plethora of criminal cases, but also having all of these various civil issues that you've had to bring up. How do you think doing all of these civil trials on different issues has helped you sharpen your skills in the criminal context? Because I'm assuming that there's very different, ways that you're communicating with a jury depending on the particular type of practice area that this trial is related to. But I'm sure that there's a lot to be learned from civil juries that we kind of maybe ignore on the criminal end. Is there anything that you've brought out of that civil experience that's been helpful in the criminal context?
Well, I think they're all helpful, yes, but I want to encourage young lawyers, those that have been practicing for 10, 15 years, whatever it is, 5 years, 2 years. I want to encourage you because I really believe you can get a lot of jury trial experience in criminal cases, and it's harder to get civil cases tried.
Yes.
They go on dockets, they're more spaced out. You do all the civil discovery, and then maybe a civil trial will take the whole week, or a lot of those terms, they don't try any trials. So I would say to you, you have a lot more of an opportunity to try criminal trials. It's kind of like this parallelism. About 85% of the law comes from criminal trials, evidence rulings, other things. Well, that's kind of like a parallel with the trial experience. If you want to do both criminal and civil, you're probably going to try 8 or more criminal trials before you try 2 civil trials. And it's just the nature of the system and how it works. To answer your question, I do believe that it causes you to think more creatively because civil remedies are very different. Whether you're putting up evidence of mental anguish or pain and suffering, or whether or not you're putting up lost wages, or whether you're arguing punitive damages, it creates a lot. It helps you to think creatively about what facts fit into the types of damages, whether they're consequential damages or other forms of damages that you're going to use. So I just think it helps you to be more thoughtful and creative by doing civil trials.
Yeah, that's really cool. I think that even from the narrative that you're trying to create to get to those specific outcomes, or this particular remedy is what we're looking for in this case, that I would imagine definitely does then kind of help with that storytelling ability in the criminal context, where we're no longer just looking at facts, where this is all in narrative format. This is all a storytelling experience for the jury.
That's true. And I want to encourage lawyers, because I really believe you become really a great trial lawyer. And I think there are a lot of people that can be great trial lawyers. I truly believe that.
I totally agree with that.
Yeah, they'll bring their unique style, and juries will relate to them. And some will be theatrical, and some will be just very informative and brief and laconic and to the point. But they'll be just as effective. So I would say to anyone, be an eclectic, take the best of everything you see, and then be yourself.
I love that. And I think, in terms of developing into that trial lawyer, as you said earlier, the practice of law, that's how you develop into that great trial lawyer. And I think you can go into a courtroom in any county and see some of these great lawyers that have been doing it for decades, give these amazing arguments and questioning. And again, you can take a ton of notes and trial tips from how you're going to prosecute your own case or defend your own case. But at the end of the day, you got to put it into practice and do it yourself. And I am sure that walking into a courtroom today on your end, if you were to go back and watch yourself on that first jury trial, you just probably, be hanging your head, hand over your eyes, because you've just learned so much having done so many of them at this point. And I think that really is the only way to get better, to do that practice. So, again, not everybody has 150 jury trials under their belt, but the only way you get there is by starting at that one. And again, that may sound like a very basic point, but again, I want to do the same thing in terms of encouraging lawyers. Just go out there. Don't be afraid to be embarrassed. It's not going to go perfect. You're going to say something that you didn't mean to say. You're going to object at the wrong time, or, something's going to happen, and it's okay. At the end of the day, I feel like most of the jurors in our courthouse miss most of that because they don't even understand what's going on half the time. So, if whatever feels like a mistake on your end, most of the people that are in the courtroom have no idea that something's gone wildly wrong. I mean, it just is going to be missed.
That's exactly right. That's why we have all these phrases like "never let them see you, you hurt." Never let them
that's
see
right.
you flinch, because it just killed you. But they may not know that, right? Yeah,
that's exactly right. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.